Hello and a very good day. My name is Divya David and this is the video presentations for Tort Law Group Assignment. We are going to be discussing about false imprisonment, which falls under trespass to person. False imprisonment is a legal term that refers to the unlawful restraint of someone which affects the person's freedoms of movement. The tort of false imprisonment is a form of trespass to the person which requires certain elements to be fulfilled to prove a legal claim. And in this assignment, we are going to be looking at 5 cases regarding false imprisonment.
I'm Hoying. Now I would like to explain first case, which is Khairuddin bin Abu Hassan and Wan Aidil bin Wan Abdullah and others. So, the fact of the case is that the plaintiff, a politician and one NDP critic, filed a police report urging an investigation but seeing no action, took his complaints abroad, gaining media attention and raising public concern. He was arrested under Section 124C of the Penal Code and detained for 6 days before being released without charges, only to be rearrested under SOSMA and detained for 28 days. The plaintiff filed a habeas corpus application in the High Court, challenging his detention under SOSMA and claiming false imprisonment. So the issue is that whether the plaintiff's 6-day detention under Section 124C and 28 days detention under SOSMA for offences under Section 124K and 124L of the Penal Code constitute false imprisonment. I will be highlighting 5 cases that all has contributed to the court final decision. First is Takako Sakau case. It emphasizes that 2 consequences will be followed when the defendant who know the facts refrain from giving evidence. First, the evidence given by the plaintiff ought to have presumed to be true. Second, court ought to have drawn an adverse inference against the first respondent. Next is the case of Putri Sendirian Berhad. It states that failure to adduce a material witness without any justification invites an adverse inference against the party who committed to the state failure. Moreover, Hassan Marsun and others' case, the defendant's lack of reasonable cause for detention amounted to false imprisonment, violating constitutional rights. Zaida Ismail case highlighted the need for credible information or reasonable suspicion to justify an arrest. In Abdul Malik Hussein case, failure to inform the plaintiff of arrest grounds under Article 5, Section 3 constitute false imprisonment. In conclusion, the court ruled the plaintiff's 6-day detention under Section 124C and 28-day detention under SOSMA will unlawful, constituting false imprisonment. The plaintiff was awarded 300,000 ringgit in damages with 5% annual interest from the judgment date.
The second case is the case of Nik Muhammad Suhaimi bin Ahmad Ghazali and Siti Farouz binti Shamsuris and others. According to the fact of the case, the plaintiff filed a lawsuit against officers of the MSCC and public prosecutor, alleging false imprisonment, wrongful arrest, harassment, and malicious prosecutions. Plaintiff was brought to the Kuantan Session Court in handcuffs and charged under Sections 468 of the Penal Code for forgery. He alleged harassment, threats, and intimidations throughout the process, including being paraded in front of the media. First issues, the plaintiff proved false imprisonment by the MSCC officers on a balance of probabilities, and the second issues is whether the public prosecutor and its deputies committed malicious prosecutions. There are several law and cases applied in these cases. The first one is Everett and Ribbons and others, where malicious process differed from malicious prosecutions in that there was no need for the plaintiff to prove that he had been acquitted. Moreover, according to Goldsmith and Sparings, when the law enforcement agency used operations or extortions to exert pressure to achieve its improper objective, this is abuse. And in these cases, plaintiff was arrested in the ensuing process. He was subject to abuse, harassment, intimidations, inducement, and harm which had affected him not only physically but mentally and psychologically. In the case of Hill and Hamilton Wentworth Regional Police Service Board, the Supreme Court recognized the tort of negligent investigations against the police because the tort of false imprisonment, misoffense, and malicious prosecutions do not provide an adequate remedy. Actual school rule was also applied in these cases where the defendant tags the victim as they find them. According to the court, it follows that in a claim of this nature, the court has to consider who the plaintiff or victims are. Some MSCC officers did abuse their powers in the course of discharging their duties, which in itself is a tort of abuse of process. In conclusions, in the High Court trial, the judge found in favor of the plaintiff on his claim.
Assalamualaikum, my name is Hari. So today I would like to make a case review of ASP Poonam Ikeling and others and Sri Sanjeevan Ramakrishnan. The fact of the case, this is an appeal of the Learned High Court Judge decision dated on 28 June 2022, which allowed the responding claim against the appellant under false imprisonment. The first defendant was applied a remand for arrest and hold the plaintiff under Section 4, Subsection 1 of Prevention of Crimes Act 1959 for 21 days from 11 July 2016 till 31st July 2016 at Kuala Lumpur Magistrate Court. 4 days after, the plaintiff filed a habeas corpus application at Kuala Lumpur High Court. The issue is whether the habeas corpus decision was conclusive evidence for false imprisonment and whether the pure condition of detention are the basis for false imprisonment. In the case of Shahruddin Abidin and Datuk Wira Abdul Samad Yusof, the habeas corpus was not conclusive evidence for false imprisonment. The function of habeas corpus is free, detenee and granted him or her for immediate release. Referring to the case Datuk Sri Khalid, Abu Bakar and others and N. Indra Pinalatambi, the pure condition of detainee could arise for trespass to person, whether battery or assault, not forced imprisonment. In the case of Shahruddin Abidin and Datuk Wira Abu Suman Yusof, the habeas corpus was not conclusive evidence for forced imprisonment. The function of habeas corpus is hit detainee and granted him or her for immediate release. Referring to the case Datuk Sri Khalid, Abu Bakar and others and N. Indra Pinalatambi, the pure condition of detainee could arise for trespass to person, whether battery or assault, not forced imprisonment.
Hi, Assalamualaikum. My name is Muhammad Hafiz Azim and I review the case of Kamal against Siti Nurfauziah. The summary of the case: the plaintiff claimed for the first imprisonment due to the forged document made by the first defendant, and also claimed for the second defendant to the fourth defendant, since the first defendant under the employer of the second defendant until the fourth defendant. There are two main issues: whether the first defendant is liable for the first imprisonment, and the second one is it second defendant until the fourth defendant also liable for first defendant action. For the law and cases, we look into the case of Timbalan Menteri and case of Tan Sri Norian. Both of the case highlighted the importance to follow the legal procedure in terms of the criminal case, and also support the measures of forced imprisonment to reflect loss of dignity and the freedom of the individual. Case of Saul Hamid against Inspector Abdul Fattah. So the court highlighted the importance to prove the damages faced by the plaintiff during the detention period, and in the case of Lister, court developed the principle, the close connection test, to determine the closeness of the nature of employment and the wrongdoing action. In the case of the JMP Kaisar, court also developed the case Lister and also highlighted that the test must be considered in terms of matrix of facts of the case. As a conclusion, court approved the plaintiff claim and made the defendant to pay 25,000 to the plaintiff.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad bin Helmi. So I'm going to talk about the case of Musa, tempat tahanan berada Kamuting, Taiping and Badrul Zaman bin B.S. Mat Zakaria. So for the fact of the case, the respondent was detained for 2 years under the Internal Security Act 1960, which was later extended by another 2 years under Section 87. And then the High Court ruled this extension unconstitutional and ordered the respondent released. And then subsequently, the respondent filed a lawsuit for forced imprisonment seeking damages for 300 days of extended detention, and then the High Court awarded substantial damages, which the Court of Appeal later reduced to 300,000 ringgit. And then the appellant argued that the claim for damage was barred under the ISA, citing Section 8B1 and 8C, which limit the judicial review of ministerial decision. Finally, the Federal Court ruled in favour of the appellant, holding the court-like jurisdiction to entertain the claim for the damages, as the discretionary power under the ISA were protected by the ouster clause. Consequently, the decision of the lower court were nullified in reinforcing the minister's authority in such matters. Issues here are: can courts hear claims for damages under Section 8B and 8C of the ISA, and does forced imprisonment qualify under these provisions, and are damages part of judicial review as defined in Section 8CD. So that's a spot. So then we have to take a look at the case that were applied in this case. So in Abdul Razak and Ketua Polis Negara, the appellants challenged the detention under Section of 733 A and 8.1 of the Internal Security Act. They argued procedural flaws and lack of ministerial discretion, but the Federal Court focused on the interpretation of Section 8B, 8C and 8D. Similarly, in Kerajaan Malaysia and Nasharuddin Nasir, the respondent's detention was ruled unlawful by the High Court. However, the Federal Court upheld Section 8B's ouster clause, bearing judicial review of ministerial discretion except for procedural errors enforcing the SA National Security Framework. For conclusion, the Federal Court upheld Section 8B and 8C of the ISA, bearing judicial review of ministerial decisions even for wrongful detention claims. The reinforces executive discretion in national security matters and limits judicial oversight.